score this week.
But none of them were killed by artificial intelligence. So.
Not yet.
That we know of.
Or not in this timeline. I don't know.
Are we live?
We
Zoom
were.
just changed its interface. I can't even tell if
It says we're live.
Are we live?
It says it's live. It's live on Facebook.
I did not click on live.
Yep,
it says live on Facebook.
We are.
But we're live on. We're live.
We're hearing that we're live.
Right? Okay.
We are good. I did not press whatever I usually press to get out of our little green room here. Hopefully, we caught Niki singing at the beginning as we went live.
We'll do it live.
AI just put us live
with their uplifting music, their song.
All right, we have chat going. So apparently we are live. Good. Okay. Zoom has changed its interface and it totally confused me. All right. Well, this is welcome to Legal Tech Week. This is the show where we talk about the top stories in legal tech and innovation. I am Bob Ambrogi, and our panelists this week. Let's introduce ourselves. Steve, you want to kick us off?
Sure. Steve Embry here from Louisville, Kentucky. I write the blog Tech Law Crossroads, and prior to that, I practiced law with a big law firm for more years than I'd like to remember or count.
And Niki.
My name is Niki Black. I'm the head of SME, which means subject matter expertise and external education. In my case, law pay and our other legal products. And I write legal tech columns for ABA Journal, Above the Law, and the Daily Record. And I also oversee and author some of the industry and benchmark reports that we put out on the My Case and Law Pay side of things. And I'm looking forward to today.
But you didn't sing your introduction. We should all have to sing our introductions. Like,
I feel like that'd be a lot of torture. For
you want
everyone.
people to keep watching, right?
Well, I don't know. Was anybody were you guys at the Startup Alley when Jackie Schaefer, a couple of years ago, I think, the Clear Brief founder?
She was really good.
I'm
not even going to lie. She was really good.
Yeah.
She sang her entire pitch. It was so cool.
She sang Queen or something like that. It was really good.
Yeah. Yeah.
Yet another reason for everyone to come to Tech Show.
Come to Startup Alley, right? All right, Victor.
I'm not going to sing my intro. My name is Victor Lee. I am assistant managing editor for the ABA Journal. Come to Startup Alley. You'll hear Queen covers, maybe Right Said Fred covers. Who knows? It'll run the gamut.
All right. With that plug for Startup Alley, Stephanie.
You had me at Right Said Fred. I don't know. I'm Stephanie Wilkins. I am the editor-in-chief of Legal Tech News at ALM.
Thank you. And Joe.
Joe Patrice from Above the Law and the Thinking Like a Lawyer podcast. The conversation I was having right before this show began online with a bunch of people was, what is the most kind of trashy, like white trashy song of all time? So you're going through all of these. We were arguing about that. There's a lot of move for Sweet Home Alabama, which is fair. I actually think that Kid Rock's like weird cover version that wasn't quite Sweet Home Alabama is worse because it's then
Werewolves of London. Yeah.
Well, not Werewolf of London. Like that's the Warren Zevon run.
No. He spliced the two together. It was like
he made Sweet Home Alabama.
He mashed them up. Yeah.
He made Sweet Home Alabama about Michigan. Yeah.
That somehow that one seems to transcend in my mind, but we'll see.
Oh, it is worse. Yeah.
All right. Well, from there, where do we go? Something I just realized that we should probably think about doing something about is that in the first week of May is actually going to be like the 3rd anniversary of our doing this show. We've been doing it for 3 years. It doesn't seem like we've been doing it for 3 years, but I was looking back. The first show is like apparently not recorded for posterity. I can't find it on Facebook or on YouTube, but the second show is there, and I allude to the fact that we had done one the week before, that it was our second show. So the second show posted was May 15th, 2020 on YouTube. So Niki, Joe, Steve, were you there at that in the first back then? I forgot if you joined a little bit later. I think
I joined a little later. Yeah.
Molly was on it. Caroline Hill was on it. Anyway, that was fun.
The weird thing about the pandemic is in some ways it feels like we just started doing this. In other ways, it feels like it was a decade ago because it's
Yeah.
just a black hole of time, you know?
Yeah, yeah. Actually, 2021. Did I say 2020? 2021, right? I think that we did it. Yeah, but that was our, it was our, one of our responses to the pandemic, being locked up. Anyway, in the world of legal tech news, not sure where to start this week. Stephanie, I actually thought your story about a large language model built specifically for law was pretty interesting. You also did a really good story about it. You wrote a really nice report about it. So do you want to kick us off and talk about that?
Sure. There's a lot. Yeah.
It is a lot.
There's a lot. It was, yeah. I mean, there's a lot of, anytime anyone claims to be the first of anything, there's a lot of, contention around it. And there's a lot of, so this is the first built from scratch large language model for commercial use, trained purely on legal info, like free. That's the thing. There are other legal LLMs out there that are like, there's a lot going on out there, which is like reminiscent of the Napster days where people are using things with illegal licenses. And so people have built legal LLMs that maybe should not have been built based on things. So this one is Dan Katz and Mike Bomarito who have built this thing from scratch.
Of course, you can also say that about all the legal research services. A lot of the start of legal research services, you have no idea where they actually got the cases and stuff. And if you ask them, it's pretty questionable. So
that's a different
that's a whole different conversation, but
yes, that will come into this also. But so they built it from scratch, trained solely on legal resources that are, so they built the architecture from scratch. So it's kind of when Bloomberg GPT built a finance GPT from scratch like a year ago. So at Codex last year, there was a big debate about fine tuning versus built from scratch. Bloomberg GPT had just come out. No one really did it again. So now they did it, and they're actually going to be presenting at Codex this year about what they did. But not only, like, they even said like the legal LLM is sort of a double entendre because it's built for legal domain, but it's also legal in that everything they trained it on is lawfully obtained, and it is, they were the first LLM certified by this fairly trained organization as copyright friendly. Everything is like complies with copyright licenses. And it's also got like a very, very low toxicity score, which is a fascinating thing because all of these, literally every big LLM out there is trained on Common Crawl, which is the corners of the internet, like 4chan and Reddit. So, and none of that is in what they've trained. So the most damning thing is like congressional testimony or whatever. So it doesn't spit out your crazy toxic uncle at Thanksgiving. And so it's just really fascinating with it. It's tons of work. It's a family of 4 models. They've released the 2 smallest ones so far.
So were they able to edit out Marjorie Taylor Greene from all the congressional testimony?
Which is why it's not zero toxicity, but it's very low.
Okay.
Zero toxicity is impossible.
I have a question, and some of you are more familiar with Harvey than I am. How is it different from Harvey? I thought that
Harvey's built on OpenAI's models.
Sorry?
Harvey is built on OpenAI's models.
Okay,
this is a whole different model.
Okay,
This is like a self-contained model.
Right.
In other words, all the data is self-contained, and then unlike some of the other ones, they don't take the data that's retrieved in response to an inquiry and run it through a public model to get the actual content.
So
it's a completely separate LLM. So if like, say all these copyright suits against OpenAI in a theoretical world, if OpenAI were to have an injunction against them, everything running on GPT-4 would go down. This is completely different. It's built from scratch. It's a separate LLM.
So Harvey is an LLM built for legal, but not necessarily trained on legal material. And this one is from scratch, trained on legal.
Harvey is GPT-4.
Yeah, everything else is fine-tuned for legal, built on an existing LLM.
Okay.
As opposed to built from scratch.
Harvey and Casetext are basically the same in that sense.
I thought it was really an interesting story, Stephanie, particularly in light of the Microsoft debacle that's going on. I mean, when I was in Legal Week,
this week?
Yeah, which is her other story. And Steve wrote about it too.
Yeah, when I was at Legal Week, I talked to some vendor, and it was a former e-discovery vendor, and they were like, oh, well, what we do is we take all the company's data, and then we enable people within the company to make inquiries on the data, like, what's my vacation days or human resources. And I said, well, that's all well and good, but like, how does that content get generated from that data? Oh, we send it out to Chat GPT and it comes back with the response. And that's, well, like, how do you know that it's confidential? But they're, and they were like, oh, well, they told us it would be. Like,
Yeah.
okay, just let's trust our tech giants here. And when they say it's confidential, of course it is. But it struck me with any of these models that are relying upon. You've got one vendor that you're buying from as a legal professional, so you have the duty to vet that vendor and make sure that they're doing what they say. But then that vendor is going to another vendor, and so now you've got like a double kind of obligation, maybe, to vet both of them. And I mean, I'm just not sure how to do that. So anyway, I thought it was a pretty interesting tie-in.
Yeah.
To your other story.
Yeah.
No. To kind of build up on the Napster analogy, I guess.
Yeah.
I guess my question would be, if you're limiting the data that goes in, kind of like with Napster, right? Or versus iTunes. Like iTunes has all legal stuff. Napster's where you get like the bootleg stuff and like the maybe the not so legal recordings that aren't supposed to be out there, but you still get them. So yeah, so I guess my question would be like, does that, by limiting the information that goes in there, then do you also limit the information that then comes out?
Yes, well, it does. And I mean, that's kind of their point, because a lot of these things out there, like the idea of these massive, you train it on everything is so that you convince, like they even said this, like it wants to be able to convince your 16-year-old that it's talking to a real person and it knows everything. But like, do you need that to draft a contract? Like, no, you don't. Law firms don't need that. It needs to know legal language, needs to know whatever. It doesn't need to know all that stuff. It needs to, and honestly, if you look at what's like that, like their funny point is like, it's amazing what is in legal, like in the public record of laws, because the Code of Federal Regulations covers everything. Like you can learn chemistry formulas from it. They're like, it has a turducken recipe in English and Spanish from the USDA. Like there is stuff in there. And it's more than you would ever need to do legal work. You don't need it to have all this other stuff. And like, so it's so much smaller, and even their smallest model, and you don't need, a $50,000 GPU to run it on. You can run it on a laptop. And so, I mean, that's their idea too. They have like 4 models that are progressively larger. And so like, if the idea is to just do legal tasks, you don't need the far corners of the internet and a $500,000 investment in massive hardware and all of this stuff, and the compute power and the the environmental impact on it too. So like, and they're scaling it, and they're like smarting smaller and see what happens as they get progressively larger. And I mean, we say small, and they're still by all appreciable standards huge, just not the 1.7 trillion parameters of GPT-4. And so, yeah, it is.
Well, I was trying to think. I was thinking about the same thing when in a similar thing. Maybe it's the point that you're making is when I was thinking about it. I was thinking like, if you go to a real lawyer, you don't want a lawyer who only knows the law. You want a lawyer who's read literature and been to movies and I don't know, reads poetry. I mean, you want a lawyer who's is able to sort of put their legal analysis in the context of real world understanding and perspective. So with AI, does that matter? It's interesting that in part what you're saying is all that stuff is in law anyway. I mean, I guess it is. I mean, if you look at just all the case law out there and get trained against all the case law, that's pretty much all the good and the bad and everything else of human nature reflected in all of that body of information, I guess.
Like, remember, like this is the model, this is the LLM, like you can build, then you build tools on top of this model. Like it's like CoCounsel is built on top of GPT-4. You can build the tool on top of this model. Like currently it can like draft contracts. You can build chatbots on it. You can build whatever and like draw from the legal models. You don't need, the flame wars on 4chan to do that. And that is where it might do, you can teach it the legalese, you can do RAG on top of it to teach it more things, supplement it with your own data, but the underlying LLM is clean with the data and based for legal, and you could add things to it without all the bias and the toxicity and all of the things that might be copyright, where you're running risk of, you know, it being shut down or things like that was their goal.
Yeah. So you saw Toby Brown's comment in the chat that this Servient one was actually the first one. I mean, I guess that's what you were saying. Is as soon as you call something the first one, everybody else is going to come out and say we were the first one. But
well, yes, and there are a lot of, I mean, there are a lot of claims to first. Some were just embeddings and not LLMs, not generative. Some of them were. There are other ones that technically claim to do this, but they were like basically like Napster things. They're like people's.
Yeah.
There's like the equivalent out there where you can like take codes and stuff that are not for commercial use and people are using them for commercial use and building things. Like all of this is like, this is the first legit thing. If you care about
all right,
complying with laws.
all right. You and Toby can step outside and fight about this.
I don't know. This is what I have been shown, and I think yes. And
This
it's
is why
also
Monica. This is why
like
Monica
people,
always hated. This is why Monica always dinged me whenever I wrote first or whenever I wrote something like that on one of my stories. She would just yeah.
Well, and also it's just like people have built their own bespoke for their own internal use, but not as a commercial for other people to use also. I mean, that's what this is. Like Evisort has built their own to use internally for their own thing, but not for other people to build their tools on top of also. So like this, we're talking like as a commercial rival to like a GPT-4 for legal. That is what this is. Yeah.
Yeah. And this is a commercial thing. They're going to be selling this, obviously. This
Yeah.
is not
Yeah. No, I mean, they're
open source.
talking to law firms that are already starting to use it or like build things on it, and it'll be as the models get bigger. And yeah.
But it doesn't have an API yet. So in theory, tech vendors, unless they use that other product of theirs, is what it looked like to me. It said you had to use their legal ops product in order to access that right now, and there's not an API right now.
Like this literally has just come out, and 2 of the 4 models have come out, and they're rolling it out. So
yeah, it's cool though. It's really interesting.
Yeah, and I mean they're just, I mean they're smart guys, and I mean like don't get me wrong, like they're investing a bunch of money in it, and like they know it's like it's a lot of work, and it's not. I mean, they're not OpenAI, but like they have. I know nothing about the pricing. Like I didn't ask. That wasn't. I like honestly I don't know. I'm not representing anything one way or another about that. I don't know.
Yeah. All right. Well, so that will be that should be a more hallucination free LLM. Is that right? There should be fewer unlikely instances of hallucinations with that. But Niki takes us back to the fact that other lawyers have not yet quite figured this out yet, and we've talked any number of times now about lawyers filing hallucinated cases, and it just keeps coming.
Yeah.
You want to update us?
Yeah. So just in 2024, it feels like every week there's at least one story of a lawyer. It's not quite that bad, but one story of a lawyer submitting false citations to the courts. And so it got me thinking. And so the article that I wrote was basically focused on the idea that judges are getting sick of generative AI and all the hassles that it's causing them. And so first, I just summarized the ones that I've come across since 2024 started of lawyers submitting false case citations. And then I learned about Rail's efforts to track all of the judges' orders and guidelines, court guidelines and that type of thing that are either have already been issued or are in the process of being drafted. There's 42 of them, I think, at this point. And the problem then becomes there's no uniformity. It's all over the place. Everybody's doing different things, which is the problem with our judicial system in a lot of ways. It's different jurisdictions, different courts, federal, state. And so this is a problem we consistently have to deal with anyway. But it's happening in generative AI to its detriment. So I wanted to include a link to the document in my post that tracks that because it's pretty useful and interesting. But then the other thing that I thought was really notable about this is that, and I've been thinking about this a lot, you know, we're all like so appalled at these lawyers who aren't reading the stuff that's being submitted. And, you know, you're supposed to read what's been submitted. We all know this. We all understand basic competence. And right now it feels like all of a sudden all the lawyers are getting lazy, but really what's happening, in my opinion, is lawyers have always been lazy. We like to think that we are, you know, and I, of course, leave myself and everyone else who's in attendance out of this category, but, but, you know, I have certainly seen some sloppy lawyers that have sloppy practices that I've worked with. We all have. And so I think, you know, what's happening is it used to be that if you ask somebody that you knew for a memo or a brief that they'd already written on a similar topic, and then you copy and paste it, and you cut and paste it and threw these cases in and assume they knew what they were talking about. And I think this happens all the time. I mean, people are submitting these things to the court, and when the court clerk reads it and is like, the law clerk reads it, or the judge, and is like, wow, this case doesn't make any sense in this context. They must have made a mistake, or they must have, you know, they must have misread it. You know, you make these assumptions that the person is operating with competence, that that's their goal. And instead, I think that what's happening with generative AI is that it is showing that that's not what happens. That people are not, in fact, reading what they're submitting, except you can prove it now. If there's no benefit of the doubt, you can't locate the case. It doesn't exist. So I think it's interesting that I think it's sort of shining a light on that, on sort of it's not all of a sudden lawyers are becoming lazy or aren't acting in a competent manner. It's been going on since the dawn of lawyers. So
Yeah.
I think that was sort of another interesting aspect of this.
Yeah. Well, what were the like remember treatises, like like I'm so old I can remember print law books, but you know, like they'd have these treatises and they're like a paragraph. Here's the law on something, and how often would a lawyer just copy and paste that paragraph into a brief or something? But they just didn't get caught. I mean, there wasn't something that people could automatically see. And fortunately, they were copying it from a treatise, which has probably got the law more or less right, as opposed to doing it from ChatGPT. Who knows, right?
Probably.
Probably, yeah, I don't know. I was thinking about the tech competence thing yesterday because I did a webinar yesterday for some lawyers in Massachusetts on sort of the current things in tech, and we were talking a lot about generative AI, and it was just a Zoom call, and there were a lot of older lawyers. Not to discriminate against older people, I am one, but there was this like just glazed look. It's like this glazed look in their eyes as we're talking about this stuff, and you feel like there's some people sitting here listening to the presentation who just want to like throw up their hands and say, "I quit. That's it. I'm done. I just don't want to do it anymore because I don't get any of it." And it's the competence part around this is hard. I mean, actually, I mean, it's not that hard to know to read a case or whatever, but I think they're so befuddled by this technology in a lot of ways that it's kind of daunting for them to think about it.
You know, I was thinking as I read the piece, Niki, I mean, with all of these examples of lawyers fighting fictitious cases and using generative, sort of wonder if it's perhaps for state bar associations to start looking at using comment aid or their version of comment aid, instituting some sort of disciplinary proceedings against lawyers that do this. Maybe not disbarring them, but you know, historically, I don't know, Bob, you probably know better than I don't think too many state bars have used comment aid or anything really.
Some
Certainly
sanctions in a few cases, but yeah, certainly not disbarment.
But I mean, you know, the examples of many of these would fit right within the rule or the comment of knowing the risks and benefits and that duty. And if you, as a lawyer, breach that duty, then that would seem to me to be a breach, same as any other ethical breach, and might call for some sort of sanctions by the bar association.
So I haven't used Westlaw and Lexis in a serious way in a long time. Like at most I like grab one site, but shouldn't there be, and I feel like this is the sort of thing that in the last decade that I haven't really been regularly practicing, somebody has done. Shouldn't there be a way to just like drop the brief in it and it pops out like, oh, you cited all these cases, at least here's the flag that goes with each of them? Like, is that not something that we've built? Because that seems easy to build to me, and that would be a
Yeah,
way in
no,
which, yeah,
they
right?
do all have brief checking software that does that.
Yeah, like,
You know,
how
you
is
can
this
absolutely do
hard?
that.
Like,
It's not
yeah,
hard.
the clear
A lot of
brief,
people
yeah.
can't afford Westlaw or Lexis, but you know,
I mean,
other
Dennis makes
companies
the
have
point
their
that
own
clear
versions
brief
of that.
exists. Yeah,
Yeah, Clearbrief
Yeah.
does that.
Yeah, I'm sure there are other like probably like Fastcase probably has something similar to it, and like you know, you know, you could even just use like what's the Justia or one of those like just to even do some of those like very basic sites that
See, I
like
know
for
you
federal
can.
cases and whatnot.
I know you can like take the time to type in each site and get the case, obviously, but I'm saying like, shouldn't there be a way to be even easier that like you've written it, you've copied and pasted from your buddy who referred it and from a couple of treatises that are out of date and all blah, blah, blah. And you've got all that in there. Just drop the Word doc in and it spits out like, look, we're not going to like go through everything for you, but the specific cases you cited, 2 of these don't exist. Like that kind of thing should not be difficult.
Hey,
to
you guys,
build.
I've got a great idea. I think
Yeah.
that the 6 of us, because
Yeah.
of all these issues with AI, let's just do this. Let's do this. We're going to make a lot
Let's
of money.
build this out. Yeah.
Yeah,
Okay.
I think so. You guys in? We good?
I just-
Well,
yeah,
you got,
I
you
would
got the
be-
my case. You got the my case money, so you can fund
Yeah.
yourself.
There we
I
go.
don't have the my case money. Let's be clear. Let's try. Yeah, let me pull up my case checkbook.
I know a good programmer who works for my case. Maybe he
Yeah,
can
I
help
do.
us.
Yeah, there we go.
One, too.
Yeah, but my point is, I just think that like it's not necessarily like we've talked about this a lot as the lawyers should be have somebody making all these checks, which is true, and that's definitely how I was brought up. But I'm saying like I think that tech probably should be further along than that. That you don't actually need to type in each individual one as an associate and read it and then go shepherdize it or flag it or however we're going to call it. You might have to do that, but a simpler solution should just be it spits out like half these things are red flags should just be a thing that it spits out to you rather
know what
and that
it
it
says.
polls.
You
Yeah,
need to read
like
the
it-
case and know what it says. At least
Yeah.
initially,
Well, no,
it's
no.
gonna
Oh.
take-
Yeah.
Fine.
Well, I see what you're saying. Yes, there is also the figuring it out based on what it said. I'm saying that half these hallucinations are these cases don't exist, or
Right.
you know, all that's the sort of thing that like a word plugin has been mentioned in the chat. Like that sort of thing should exist, right? I don't
Well,
know.
this
Go ahead.
Does exist.
this is a dumb question, but like, I know nobody on this. We're all talking about like, are people not figuring out the tech and doing whatever? But like, outside of this and our audience here, like, do people still not know that this stuff does this? Like, why is this still happening so much? Like, how, like, is it still, do people still, are there that many people out there that still just don't understand that this happens? Like, do you know what I'm asking? Like, I'm just like,
Well,
I don't know.
that's what I was
Yeah,
saying about this thing I did yesterday. These people
think
were
about
like clueless about generative AI. A bunch of the people on this call yesterday. It's like they had not. This is like something they were not tuned into was happening.
Also,
you know
Like,
what,
how
though?
do we teach them? Like, how do we tell them?
We make them all come to our Friday panel.
No, but you know what? Though, if I didn't follow this, I wouldn't think that the technology would do that. I mean, why would you, right? I mean, why would you buy
Even the New York
technology?
Times wrote about it. Like,
Well, yeah,
I don't know.
You know,
Well,
Who reads the New
thing-
York Times?
The other thing
Who
is,
reads newspapers anymore?
yeah.
I just wrote my Daily Record article. I'm writing a 2-part series on the ABA's Profile in the Profession report, which came out at the end of last year. But there's a whole section on, you know, lawyer mental health, depression, suicide, drug use, alcoholism, you know, like all these different anxiety, stress, you know, leaving the profession because of it. And I think that, and you know, we all know we have some of the highest rates of all these things in our profession. And I think that that is also contributing to some of this, right? Like lawyers are overwhelmed, they're stressed, they're depressed, they're on drugs, they're suicidal, like, and so sometimes they're just cutting corners. The last thing, forget about reading about what's happening in tech and what ChatGPT does. They have this thing due, it's due the next day. Someone told them about this, just go to this website. They don't even know what it is, but they put it there and it looks great and they submit it. And this is meanwhile someone who has a drug addiction. I'm not saying any of the, by the way, just to be super clear, I don't know any of the lawyers that have had any of these issues. I have no idea if they have any of these issues at all. And I'm not suggesting that they specifically do. I'm just saying as a profession, there are a lot of reasons that we cut corners, and some of it's just inherent in the stresses and challenges of being a lawyer, I think, that sort of will sometimes lead to this. with or without knowledge of ChatGPT.
I mean, again, on this panel I did yesterday, there were people who had never heard of case text, never heard of case text co-counsel, had no idea that Thomson Reuters Westlaw now has supposedly generative AI features in it. I mean, all news to them. So, yeah.
Yeah.
Yeah, I think, those of us that are sort of in this area, it seems shocking, but I was at a conference of lawyers, and Niki, you've been to them too. And I mean, it is striking when you talk to these people, they don't really, it's like, what are you talking about? Kind of thing. Their knowledge level and their comfort is very low.
Well, and we all remember what it was like to be practicing, on a regular basis. Like, you're overwhelmed and now with email, lawyers having to respond to emails and text messages. And I mean, that's the whole selling point for my case and all this software, right? Is like, you're overwhelmed. We can reduce the stressors. We can make it easier for you to communicate. We can take a lot of these rote things off your plate, because lawyers are truly just completely overwhelmed. Just the day-to-day tasks of running a practice, staying on top of your caseload, staying on top of changes in the law, like that was overwhelming before we had all this tech. And then you got to learn how to use the tech. And even though it's going to help you become more efficient, you got to get over that hump of learning it and choosing it and implementing it. And that's just such a hurdle for people that it's hard for them to envision doing it. And so then they're just stuck, and they have something to do the next day, and they just use this random website someone told them about.
It seems like it's an easy way to get the work done without really, understanding what you're using and probably the problems with it.
Yeah, no, and I know
we were
that.
talking about this week with the lawyer who was so overwhelmed that she made up an email because she forgot to file a case for a client and
made up an email that she had been
so
fired.
she made up an email to say the client fired her before she fucked up.
Yeah. No, and I don't expect the average person out there to be like, yes, I understand what co-counsel is, but like, how did we go from, I don't know, I always used to have to check my work to, oh, this thing must be magic. Cool. Like, I mean, I feel like there was like a giant leap there. Like, that's a very big leap. I don't know.
Yeah, no, it's true. I mean,
Well,
that's really the bottom line.
Yeah, but the same token, I mean, you were a lawyer who would always check your work, but we all know a lot of lawyers who don't check their work even before this tool came out.
Oh,
yeah, I mean, I guess that's true. Yeah.
I know people that were, I mean, first of all, in the public defender's office, we were all committing malpractice. We had caseloads of 600, at least in the office I was in, of misdemeanors. Like, we were committing malpractice daily, because you had no other choice. But I know plenty of lawyers that would absolutely do something like this. And I can think of exactly who they would be off the top of my head. I mean, there are some lawyers, this is just their MO. This is how they operate. And they're run the gambit in terms of solo, small firm, large firm, and they rely on the people below them to do all their work for them. They submit it, they act like they did it, and half the time they don't even know what they're talking about. This happens all the time.
And it is true that federally, it's been difficult to do this for quite some time, to hallucinate things for a while. But at the state level, it's been such a wild west for so long that, like, you could get away with saying that there was some state case, and people could be like, I can't find it. And they're like, oh, there? Oh, you wouldn't be able to find it there. Yeah.
Well, and Niki, you started out go ahead.
That was not to mention the lawyers that they will cite a real case. The problem is that the real case has nothing to do with the proposition for which they're citing it. I mean, that happened all the time. And the problem always was that, you'd argue it to the judge who didn't have time to really figure out who was right and who was wrong, or the resources to go read it. And so it's just a shouting match in the courtroom.
They got the benefit of the doubt, right? And now you can't give them the benefit of the doubt if the case is literally made up. Like, there's no benefit of the doubt there. Like, what, did you pull this out of thin air? Absolutely. This isn't real. And this proves that they did that. Whereas before you couldn't prove it, and everyone just got the benefit of the doubt, I think.
Yep.
Yeah, I mean, I guess I do know this is all true. I'm just like,
wish it wasn't.
I know. And I am never, I mean, Joe will confirm this, that I am never like the optimist in the group. And I'm never the and I'm just like, really, people, come on. I don't know.
Yeah. Well, so Nikki, you started off, you were talking about that story by saying judges are getting fed up with lawyers not doing their research. And fortunately, judges, they always do their research and they're always thorough in that, right? Right up to the Supreme Court, right, Joe? Is that fair to say?
Yeah, so this is somewhat a tangential story, but this week there was the hearings on the abortion pill nationwide injunction, which ties into what's going on with forum shopping rules. This was a case brought by recognized hate group Alliance Defending Freedom that they brought in a Amarillo courthouse, guaranteeing it would go to a Trump judge. That judge then said, "Looks to me like the FDA didn't understand science as well as I did, so ban the abortion pill." This case cruises through the Fifth Circuit because that's what the Fifth Circuit does. Supreme Court hears arguments, seems less than impressed with it, and will probably overturn it. That said, probably not overturning it on the reasons that a lot of people might want. Seems as though there's a conservative disdain for nationwide injunctions that seems to be helping cobble together a potential majority to strike this down. That long-standing disdain for national injunctions stems back to, when Democratic district judges would say things like, "Hey, you can't segregate schools" and stuff. And so this has existed for a while. And now, even though it's the shoe is on the other foot, a few of the justices are not, are standing on a principle. So on that level, good for them. On the other hand, during the oral arguments, Neil Gorsuch makes a very confident, I understand this claim to the lawyers pushing for the abortion pill ban that I went back and checked, and exactly 0 nationwide injunctions were ever done during the Roosevelt administration. This was met immediately by a law professor who has written an entire law review article talking about how there were nationwide injunctions during the Roosevelt administration. The article is actually really good on other levels. It actually talks a lot about the weird nature of this myth that these injunctions didn't exist until the late 60s or something. He's like, no, they didn't. They existed this whole time. Here's several of them, and has cites. But what got me about it was you've now got this justice on the Supreme Court willing to not just be wrong, but to be wrong to the point of, I went back and looked. And I don't know if he looked at ChatGPT or something, but all he needed to do is type this into one of those more accredited research tools, and it would have popped up at the very worst this article that explains that this is true, if not the cases themselves. And yeah, well, yeah.
The article was before. The article was out before Gorsuch said this?
Oh, yeah. No, Gorsuch said this on Monday. This article dates back. Oh, yeah, no, this is a whole thing. And he is talking about the Franklin Roosevelt administration, but there was a Department of Labor was enjoined as part of that, part of the New Deal, like disliking the New Deal stuff. And that is on the record. And that is what this law professor's scholarship is all about. So the law professor was particularly exercised that nobody bothered to do any of this research. But what got me about it was really what is going on at the high court that this is happening, that we now have. Like, I think it comes to a technology story, because if you're going into those sorts of situations, presumably you or your clerks, and Gorsuch seemed to suggest it was him by saying, I went back and checked. What is going on there? And if these are the kinds of research, procedures that these folks are doing and getting away with, like, what kinds of examples are we setting for folks? And that's the part that gets me. And it becomes a tech story to the extent that maybe it is hard and you can shrug and say, I wasn't able to get through every book in the world, but what kind of example are they setting of, we understand that these certain tools exist that do have the ability for me to get this answer and get it right? And on the advocacy side, how is it that they aren't able to go, what are you talking about? Of course it's been around this long. What kind of prep is going on there? It struck me as a tech story just to the extent that I was like, none of this should be happening to any of the parties in this debate.
where
Right,
he's going.
sorry.
Yeah,
That's
yeah, I agree. I agree with you, but it also kind of shows that for some people it just doesn't matter, right? I mean, like most of the judges have already made up their minds. They're not, like second coming of like Clarence Darrow could come up there or Daniel Webster come up there and give the most convincing legal argument. It wouldn't matter. They would still rule a certain way.
Right.
And even if they're completely wrong with their facts or with their arguments, they're still going to vote that way because that's how they want to vote. And I think that it's reflective of like our politics in general, that like truth doesn't really matter anymore. Really, it just matters, what people believe and like how loud they say it and like how much gets amplified and whatnot. And so, yeah, I just think that it's kind of endemic. I wouldn't have guessed that Gorsuch would have been the one to do it because he seems a little bit more like, I would. He wouldn't have been the one that I would have guessed that would have been that forthright about it. But we'll leave it at that.
I mean, I guess if he hadn't have said, I went back and checked, I wouldn't feel quite so chagrined about the whole thing. But to say it didn't happen and I went back and checked, that's kind of bad. But it's not the. I mean, there have been several cases since the new conservative majority came on board where they've kind of ignored the facts of the record and just stated the facts were something other than what was in the record.
Well, and Gorsuch in the school prayer case just made up a bunch of facts, but that's a great
the one I
point.
was
It's
thinking
not,
of.
yeah. It's not just that, because a lot of times justices ask questions they know the answer to. They say things like, I mean, is it you make this claim, but are you aware of any case that happened? Blah blah blah. They say that, and they think they know the answer. But this was just like, I went back and checked and I know it's not there. And it's like, then you failed. You failed legal research. I'm sorry. Go back to square one. Do not collect $200.
Well, and along I'm going to take issue with the idea that this is something that is like a new political thing, actually. Like I totally agree with both of you, Victor, and you, Steve, that this is like this idea of, it's like the echo chamber, like people just buying into their echo chamber. But I honestly, I think it's more like power and politics versus that sort of drives this stuff, not trying to, sometimes it has nothing to do with like being on one side of the political, one side of politics or the other. That always brings me back to in law school, in con law class, there was this one case that had to do with how the reason that a regulation didn't apply to the airport in DC to Reagan, and why it should be allowed to stay open, like it was going to get shut down for some reason. I don't remember the specific facts, but the whole entire class, the professor kept trying to have us explain this holding that made no sense. Like it made no sense based upon the law that existed, and nobody could adequately explain how they came to this conclusion. And at the very end, the class professor said, "This is the airport all the Supreme Court justices fly into. It makes their commute much quicker. That's why this happened." Like, so it had nothing to do with the facts of the case or anything. The law was completely convoluted to come to that outcome that they wanted. And they do this all the time. And in that case, it simply had to do with their particular convenience, right? Like what would make their lives easier. So, I think that this happens all the time. We're just seeing it happen a lot more right now on these politically contested issues that are really changing the fabric of our society. And but I think the fact that's the most notable, that he literally lied, like Joe was saying, that I looked it up myself. Well, maybe he did, and maybe he looked, I don't know what he could have possibly used this. Maybe he searched it on ChatGPT.
Yeah.
Maybe his law clerk did.
Right.
Well, this could be an appropriate time, Victor, to talk about your story, because the EU is maybe trying to do something about trying to get some facts back into the picture.
Yeah, and when we talk about this EU law, for a few weeks now, and how it's a pretty good model for other countries, particularly us, but because we can't do anything in this country anymore, then it's probably not going to happen here for anytime soon. But yeah, like they're gonna. So the Politico had a story that was picked up by other venues as well, that the EU is going to order big tech firms to help them basically have more secure European Parliament elections in June, and basically like Facebook, X, YouTube, TikTok, and those other major purveyors of in social media Like they're going to be basically have to moderate the content a little bit more. They're going to have to, I think, they have to post when things are deep fakes or if things are disinformation, and the fines can be pretty hefty. It's like up to 6% of the global revenue if they fail to comply with the law, which seems like a pretty good amount. And obviously, we'll see how it works. I mean, the devil's always in the details with these things, but at least it shows that they're actually trying to like do something to combat this spread of misinformation and the spread of disinformation and weaponized falsities and whatnot. And again, it would be a nice thing that we could import and apply to our elections, but that's not going to happen anytime soon.
Yeah. Does Truth Social operate in Europe?
Well, considering that they're valued at what, like $11 billion or something, they could easily open up a I'm always remembered of that. I think it was Silicon Valley when they talked about how it doesn't matter what you produce, it doesn't matter how much money you make, it doesn't matter even like if you're even profitable, it just matters what other people think you're worth. And
right.
Clearly there are people that think that Truth Social is worth what, 11 billion or 7 billion or whatever it is now. I mean, more power to you guys. I hope it works out.
Go figure. Hopefully it works for Bitcoin too. I've never been on Truth Social, but I didn't realize until I was reading an article about it this week that their version of a retweet is a retruth.
Yeah. Well, all the tweets are called truths.
Tweets are truths.
Yeah.
All tweets are truths. I love it.
Yeah. So whenever a certain somebody,
talk about hallucinations.
Whenever a certain somebody writes all caps missives at like 2 a.m. About Joe Budden, then those are truths.
That's funny.
All right. Well,
checks out though. Makes sense.
Speaking of pillars of society, Steve, you got some stories about how law firms and law firm partners are exemplars for the rest of us, right?
Yeah, it is. There were actually a couple of articles, one by our friend Jordan Furlong, who's one of the more astute writers in the field as far as I'm concerned. But he was telling the story that he went to a law firm to give a program, and he was explaining to the partners in the room that with all of the new technology tools, we may have to come up with a different way to value our product as opposed to just how many hours we spend. And so after it was over, they were in the lunch line, and one of the partners said, well, like, how can we like come up with that? And Jordan apparently spouted off 4 or 5 things, and the guy said, well, I don't think I could sell my partners on any of those. And so Jordan from that kind of highlighted the fact that in most law firms, it's all about short-term profits, the end of the year profits, and how to divide those up. And almost no law firm has invest money back in research and development like a normal business would do. And that's really, it's not terribly surprising given that the fact that it's all about the money at the end of the year. B, most law firms they're not necessarily totally consensus driven in decisions, but in many respects they are. There's not a CEO, there's not a board, there's not shareholders other than the partners. And so the partners who own the firm are also not business people. So you put all that together, and it's easy to see why law firms tend to take a very short-term view. Cut me a check at the end of the year for my share, and next year let's start all over again with no thought to the future. The other thing that I saw was a post by Colin Levy on his LinkedIn page, and he's been on this show I think at least once, and he was quoting a federal judge who started a bench trial with the quote that it's just how law firms work. Partners stab each other in the back all the time and then just go on, which, there's some truth to that when you look at the business model and how compensation is governed in most, at least big law firms. I mean, compensation in law firms is driven by 2 factors. One is origination credit. Who gets the credit for the business? Well, that automatically leads to fights. I'm more worthy than you, or you're more worthy than me, and I need more of the credit, and you should get less. And I mean, you've got two good lawyers going at it on an origination credit fight. I mean, obviously there's going to be some manipulation of the facts when that happens. And the other thing that it occurred to me why this is the case is compensation in law firms is typically determined by determining your share, your percentage, and that's a zero sum game. Because if my percentage goes up, somebody's percentage has to go down, and that lends itself to partners fighting among themselves, particularly if you don't make budget and you have a down year. But even if you have a flush year, they still have the same arguments because I want my share, and my share should be higher than yours, and I should get more of the profits, not less. And so the whole model kind of lends itself to not taking a long view on the one hand and being sort of adversarial and competitive amongst partners on the other, which both of these pieces kind of bore out. I thought it was kind of interesting to kind of shine the light on what we all sort of know, but it's sometimes good to see it.
I was going to say, is there news here? It's like dog bites man.
Yeah, no, I remember when I used to work at ALM, we would like report on this kind of stuff, and like I always wondered with some firms like Kasowitz and like those firms where like you have just one guy determining the compensation for everybody in the firm. I'm like, how is that guy not like the most hated person in the whole law firm? Like, unless he somehow has some formula to make everybody happy. Like, there are gonna be some people that are gonna be like, hey, wait a minute, that's not fair. I brought in this client and I did this, I won this case, and this person has been here for less time than me, and they made more money. That's not fair, and blah blah blah. Like, so I never understood how that person could like just stay sane, because it's just I would just go nuts if I had to like do all that by myself.
I went to work early in my career when I was a few years out of law school. I went to work for a firm, and they recruited me by saying, we're really different. Everybody here is a partner. And the day you walk in the door, you're a partner. And I said, man, that sounds great. I'll be a partner. When I got there, I discovered some people were more partners than other people. The only thing I uncovered from being a partner was I had to pay my own quarterly taxes and Social Security. It's like, what a deal this is.
I'll never forget a firm I worked in, only had one woman partner, and she had an off year. I shouldn't have known about it as an associate, but one of my sort of mentor partners in the firm told me, I think I was telling him I'm concerned about whether if I make partner, if I'm going to be able to make that, minimum every year, or else I'm going to be making less than I'm making now as an associate in the years that I have an off year. And I'm not from Rochester. And, I was expressing legitimate concerns. And he said, oh, well, don't worry about it, because, woman partner didn't make it this year. And her good friend, like she had a really good friend who was a partner, he gave her a portion of his. So she made it this year. And he acted like that was a really great thing. But I was like, why are you telling an associate this? Like, there's so much wrong with this. Like, he undermined her by telling me this. And that in and of itself made me think that this probably isn't the best place for me to hang my shingle internally, if you will, because it's, sometimes there's these weird undercutting things like that they'll do because there's a little bit of disagreement that like she didn't work hard enough. And so we're going to undercut her in this other way, even though he had such a great year. He gave her some of his percentage, but that type of charity stuff shouldn't be happening. You should be valuing people for what they bring across the board and not giving them demerits in one bad year. I think the whole setup is just an awful way to place a structure in which to work. It's horrible. And that also contributes to suicides and depression and drug use and,
Part of the problem too is, most firms have a compensation committee, and it's kind of a subjective sort of determination about what your share is. But if you have a very large firm, it becomes really difficult for people on a compensation committee to really gauge a particular partner's contribution, right? Because either that partner is in a practice area you know nothing about, or they're conflicting claims from other people, or they're not in the same geographic location. And it gets really, then you start getting personalities in play, and the people in the compensation committee is powerful because everybody wants to suck up to them. And so it's a real mess. nothing.
Yeah. All right, I'm going to wrap us up on a good news story basis because we've often talked about tech to enhance access to justice, and I had a story. It's just sort of a small example, but I thought it was an interesting one of where a legal services organization in Los Angeles was holding weekly in-person, or actually a couple times a week, I guess, in-person law clinics to help with conservatorships in Los Angeles. You know, where it's basically like a guardianship, I think is what it's often called in other states, where appoint somebody to make decisions for somebody who's incapacitated in some way. But these clinics were so overwhelmed with people showing up for them for all sorts of legal problems. They would see legal clinic and people would just show up. It had nothing to do with guardianships often. Some of them were, but they were just getting overwhelmed. And they were realizing also that a lot of people just couldn't make it to these clinics because they didn't have childcare, or they had to work, or the transportation issues or whatever. So somebody said, maybe we should do this online. And they connected with Theory and Principle, Nicole Braddock's company, and basically developed an online version of their in-person clinics. And it's been it just launched it in January, but apparently it's been successful so far. And they're still doing the in-person clinics for people who aren't web savvy or whatever, but it's dramatically reduced the caseload at their in-person clinics. It's reduced staff time. I mean, it's freed up staff time to do other stuff for the legal services agency, and so it's just a nice example of a legal services agency using tech to better serve the population that they serve and take some of the workload off their staff. So, anything else anybody want to talk about in 1 minute left? All right. Well, we will see everybody next week. Have a good Easter if you celebrate it, and otherwise have a good weekend.
So long, everybody.
Bye.